Can you hear me? Can you hear me? Let me know when we are live. Hello, hello, hello. Good day again. Welcome to Dr. Olu Asekun podcast. Thank you for joining us again. We do this every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific. And that is currently 6 p.m. Nigerian time. Remember to invite your family, friends, and colleagues to be a part of this. Here we provide free information on immigration matters every week. So thank you for tuning in. Today, we'll be discussing removal of condition. We'll be discussing removal of condition. So while I talk about it, if you have questions, start sending in your questions. We'll be discussing removal of condition. Now, there are some types of petitions that requires the immigration services to issue what we call conditional green card. Conditional green cards are as valid as any other green card. The only difference is that conditional green cards usually expire in 2 years. It is only valid for 2 years. The reason for this, in the case of employment-based, conditional green cards are issued for investors, EB5 investors. But in the case of family petitions, conditional green cards are issued where the marriage that is the basis of the petition is less than 2 years on the day of approval. So in both cases, conditional green card will be issued, which is green card that is valid only for 2 years. Now, 90 days before the expiration of the 2 years, an applicant is required to file a application for removal of condition, that is to extend the green card. Now, this application for removal of condition, in the case of family petitions, the applicant and the petitioning spouse must file these joint applications. But in the case of EB5 investment, the applicant is the only one that is required to file the petition, but the applicant must provide evidence that the funds was actually invested. So all these are the requirement for submitting application for removal of condition. I'm going to treat the two types of removal of condition separately. In the case of EB5, that is removal of condition based on a 2-year green card that was approved based on investment. Now, for every investor who is requesting a green card through investment, the investment amount must create at least 10 American jobs per investor. At least 10 American jobs per investor. So now, when it is time to file the removal of condition, the regional center, there are two types of investment visa. One can be invested through a regional center, in which case currently the investment amount for that is $800,000. The other, an applicant can do the investment himself or herself. The amount for that currently is $900,000. So if the investment was done through a regional center, the regional center will have to provide evidence that minimum of 10 American jobs have been created, and this investment was also done in an area that was approved, because for the regional center investment, the investment must be in an area that is designated by the US government as having higher unemployment rate than the national average. So all this documentation of employment, compliance with the initial approval, all this evidence has to be provided in addition to the application for removal of condition. So it is only after all that is done that the application for removal of condition will be approved. That is in the case of employment-based. Now, let's talk about family-based. For family-based, the applicant must submit an application for removal of condition jointly with the spouse. Because the whole purpose of giving a conditional green card in the first place is just to be sure that the marriage, which forms the basis of the conditional green card, that marriage is a valid one. Sometimes, especially where applications are processed timely, sometimes at the time of interview, the initial interview, maybe the applicant has not even been given social security number. Maybe the applicant has not well settled, does not even have driver license or anything like that. So it may be difficult to commingle assets, especially in a situation where the application is processed timely, meaning that maybe as soon as the application is filed, probably within 6 to 8 months, they have already been invited for interview. So at that stage, they may not have a lot of things together because the applicant may not have social security number, the applicant may not have employment authorization document, the applicant may not have a driver license, the applicant may not be able to get his or her name into a joint commingle of assets with the petitioner. So the government recognizes all these shortcomings, all these problems that, yes, based on the timing of the marriage and the petition, the applicant may not have all these things. But the fact that the applicant do not have these things does not mean that the marriage is not valid. But at the same time, in order to be sure that the marriage is actually valid, so that is why they give conditional green card. Okay, take this green card for 2 years, go and use it, and come back in 2 years' time. By that time, having been granted green card, having been given social security number, having been given driver license, what will now be the justification for not commingling asset? There will be no justification. So that is why they require the applicant and the petitioner to submit a joint petition to remove condition. So at this stage, if the documentary evidence is overwhelming and there is no red flag, the removal of condition can be approved without an interview where there is no red flag in the case. But where there is a red flag, or where the applicant and the petitioner does not have substantial evidence, they may be invited for an interview even when the conditional green card, the removal of condition is filed. They may be invited, and depending on the nature of the red flag or the nature of the documentary evidence, and also depending on who the individual officer who is going to conduct the interview is, the applicant and his or her spouse may be separated and questions asked. Don't forget that every documentation forms part of public record. So the government have access to the public record. So they may actually determine, they may investigate, they may be able to verify if all the documents submitted are genuine, if all the documents submitted actually show that the couple live together. So they will be able to make that determination. So it is always good to document relationship, especially if you are given a conditional green card, which will require you to apply for removal of condition, it is always advisable to document your relationship properly. Please keep the questions coming in. Keep the questions coming in. It's always good when we have questions to answer so that we don't just keep talking. So let this not be a monotonous conversation. Let the questions start coming in. We are discussing removal of condition. Removal of condition in a family-based petition and removal of condition in investment-based petition. So we are discussing removal of condition generally today. So keep the questions coming in. Keep the questions coming in. Keep the questions coming in. So in a family-based petition, if the after the approval of the initial green card, the conditional green card, the green card that is valid for 2 years, if the applicant and his or her spouse are having trouble with their marriage, that does not mean that the petition will be denied or that the petition will be approved. Every case is different, and every single case, it depends on the nature of the disagreement. One good thing about it is that the law does not require that a marriage must work. The law does not mandate that a marriage must be viable. Instead, what the law requires is that a marriage must be entered into in good faith, not for the purpose of evading immigration law, not for the purpose of getting green card, but it must be a good faith marriage. So where the marriage is a marriage of good faith, the divorce or the separation of the couple may not in itself be a ground for denial, where it can be shown that the marriage is in good faith. One thing I can assure you is that for every case where the marriage has failed, or where the couple have separated, or where the couple are divorced, in 100% of the time, there will be an interview. Such a case cannot be approved without interview, because the government will want to inquire into what happened, what led to the divorce, and also inquire into whether the marriage was in good faith or it was based on intent to get green card only. Okay, I think questions are beginning to come in. The first question: can you speed up a removal of condition filing? Well, the earliest you can file it is 3 months before expiration. The initial green card is valid for 2 years, and you can submit it at least 3 months, 90 days before. You cannot file it earlier. If you file it earlier, the application will be rejected. The earliest you can file it is. Next question: is an interview always needed for removal of conditions? I think I've already answered that. Where the application is jointly filed in a family-based removal of condition, where the application is jointly filed, the petition can be approved without interview. But where the marriage has failed or is failing, or there has been separation, it is not possible to get it approved without interview. And of course, in the case of employment-based investment conditional green card, usually there is no interview. 90% of the time, it can be approved without interview. Only in very small percentage are interview required. Financial evidence of the relationship, interview can be waived. But if it is not a joint filing, if it is based on a waiver, then interview cannot be waived. The next question: Is it possible to attend an I-751 interview without your spouse? Well, if you are going to attend it without your spouse, it means that your petition cannot be based on joint filing. The answer is yes, you can attend it without your spouse, but your petition cannot be based on joint filing. If your petition is based on joint filings and you appear alone, the petition will be denied. However, if the petition was based on the fact that your marriage has failed, but the marriage was entered into in good faith, and you are applying for waiver of joint filing requirement, then you can appear for the interview all alone. What happens if your spouse passes away while you are in the process of removal of condition filing? Again, if your spouse passes away, that will be converted to a widower petition. There is provision for that in the law because the law recognizes the fact that human being can die at any time. So there is provision for that in the law. So where the spouse or the petitioner died, the petition will be converted into a widower petition and it will still be adjudicated. Again, the fact that your spouse died does not mean that the petition is going to be automatically approved. No, they still have to look at evidence that, okay, before the death, were you living together? Were you commingling your asset? In fact, in most cases, and I've seen this several times, multiple times, we have seen this. In most cases, if the petitioner who died was not living with the beneficiary, most of the time the death certificate will show it, because the way death certificates are written in this country, you will have to indicate who reported the death, who is the informant. So usually the death certificate will have information about marital status of the deceased, where the deceased died, what address, who reported the death. So if you are not living with your spouse at the time of death, your name is not going to show up there. Even if the death certificate indicate that he or she is married, it will still not have your name as the informant. And these are the kind of things that will trigger investigation with immigration, because they expect that if you are living together as husband and wife, you should be there at the time of death. You should know what happened. Although it does not automatically mean that you have to be the informant, because you can still be living together and not be available at the time of death. Maybe you went to work and something happened, the man died or the woman died before you came back from work. So that could happen. But the point I'm making here is that whether the excuse is legitimate or not, it would still raise a red flag. If your name is not on the death certificate as the informant, it will raise a red flag. The next question: what happens after an I-751 interview? Of course, it depends on whether there is adjudication on the date of the interview. Usually, when there is an interview, the officer will take a decision after the interview. So if the officer is satisfied that the couple is either living together or the waiver of the joint file, where the beneficiary is placed in removal proceedings, the beneficiary will have the option to represent the removal of condition before the immigration judge. So the immigration judge will have the opportunity to look at it again and determine whether immigration was right or wrong before they can take a decision regarding the beneficiary. The next question: can I file for divorce from my spouse during the removal of condition process? What can happen if I do? Well, I think I've already answered this. What matters is whether your marriage is legitimate or not, whether your marriage is in good faith or not. The law does not say that a marriage must work. What the law says is that you cannot enter into the marriage for the purpose of getting green card. You must have entered into the marriage in good faith. So if you can prove that you enter into the marriage in good faith, it just didn't work. How do you prove that? You have to show evidence that during the period of the marriage, you are actually living together as husband and wife. You are actually commingling assets as husband and wife during the time of the marriage, and you also show the intent at the time of the marriage. But again, the law does not impose the impossible requirement that every marriage must work, because even among multiple Americans, marriages fail. So this is not peculiar to foreigners. So marriages can fail at any time. So the law does not impose that requirement that a marriage must be viable. What the law says is that the marriage must have been entered into in good faith and not for the purpose of evading the immigration laws. If my removal of condition petition is taking a long time and I'm otherwise eligible for naturalization, can I file N400 or do I need to wait on the decision for my I-751? Yes, if you are eligible for N400 and your removal of condition has been pending, you can apply for citizenship while waiting for the removal of condition. In fact, application for citizenship will probably expedite your removal of condition. But I want to warn you, if you are not sure, don't apply for citizenship, because the requirement of citizenship is different from the requirement of removal of condition. And if your marriage failed and you don't have substantial evidence, you can still get away with it with removal of condition, but you cannot get away with it with citizenship. Because one of the differences between citizenship application and green card application is that in the case of citizenship application, moral character is one of the requirements. Moral character is not a requirement for green card. For as long as you don't have criminal record, moral character is not a requirement. For example, let me give you examples of what some of the things that constitute moral character. If, for example, you are owing IRS, let's say you have overdue taxes, even if you have an agreement with IRS to make payment plan, for citizenship purpose, that can still lead to denial. Because as soon as they see that you didn't pay the tax as at when due, that can be evidence of lack of good moral character, and citizenship can be denied on that ground. In addition, maybe you are an habitual drunkard, but you have not been convicted. You have not been charged for it or even been convicted of it. It is not a disqualification for green card for as long as you have not been convicted. But in the case of citizenship, even if you are not convicted, you can still be disqualified on that basis. Another example, if you have a child, either in the US or outside the US, and you cannot show evidence that you are supporting that child, citizenship can be denied on that ground. Whereas that is not a requirement for green card. You don't have to show that you take care of your children in order to get green card approved, but you have to show it before citizenship can be approved. So there are lots and lots of things that could create a problem if you are not sure. And guess what? If you file application for citizenship while your application for removal of condition is pending, if the citizenship application goes wrong, it will definitely affect the removal of condition. But if the applications are separate, If the removal of condition is approved, if you run into trouble later with the citizenship application, you will have additional relief. At least one of the reliefs you will have access to will be 237A1H waiver, which you will not have the opportunity to apply for if your removal of condition has not been approved. So every case is different. Whenever we discuss immigration law, I always want you to understand that there are no two cases that are the same. Every case is different, and that is why it is always good to consult with a professional, somebody who knows what he is doing, somebody who understands the way immigration law works. The next question. What happens if my I-751 is denied? Am I still a resident? Well, if your I-751 is denied, you are not a resident, because I-7 a conditional green card is different from a permanent resident. Permanent residency is when you have 10-year green card. Conditional green card, conditional resident is when you have 2-year green card. So if your conditional residence application is denied, you are not a permanent resident, and you cannot enjoy the benefit of a permanent resident. How can you automatically extend your green card for at least 18 months? The receipt notice will extend your green card for 18 months. So that is to give immigration the opportunity to process the removal of condition application. If sometimes the receipt notice may give you an extension up to 24 months. And sometimes, even after the initial 18 months, you can get another receipt notice extending the conditional green card by 24 months. But assuming that you have 24 months extension and the 24 months expired without the removal of condition being adjudicated, you can call USCIS and schedule an InfoPass appointment so that they can stamp your passport as proof of your conditional residence pending the adjudication of your removal of condition. So for as long as the case is still pending, they will continue to extend your conditional green card by 1 year at a time. How can I prove my legal status? Okay, I think that's the one I just answered. Can I travel outside of the US if my green card expired and I have my I-751 pending? Yes, if you have the extension, once you have the automatic extension, either 18 months or 24 months, yes, you can use that extension together with your green card the way you used to use your green card. So yes, you can travel in and out of the country. It is the same way you use your green card, you continue to use the green card plus the extension. So you have two documents that you have to show whenever you are traveling. The green card that is expired and the extension that extended your green card by 18 months or by tradition. Well, usually the law requires you to apply for an extension before the expiration of the 2 years. If, however, for any reason you were late, you didn't file it before the expiration, you can still file it after, but you will need to provide an explanation. You will need to attach a letter, a detailed letter, probably notarized letter, explaining why the delay, why you did not file it at the time you are supposed to file it. So with the explanation, your application will still be accepted and processed. How long does the process take? Well, That is something that we do not have control over. Since COVID happened, a lot of applications are not being processed timely. So, and removal of condition is one of them. We cannot really predict how soon this application can be processed. But if you want to know the processing time, current processing time, to make it easy for you, you can log into our website, oluasekun.lawyer. Once you get there, click on links. Once you click on links, it will take you to the page where you can check the status of your application. On that same page, if you scroll up, you will see an icon that says processing time. So if you click on the processing time, it will give you an idea of how long the processing time is. But I want to tell you, the processing time sometimes may be discouraging because of the lengthy period that is stated there. Many of these applications does not necessarily mean that it will take that long, but USCIS is putting up all those extended periods where the marriage that form the basis of the petition, where that marriage is less than 2 years on the day of adjudication, then a removal of condition will be issued, which means only a 2-year green card will be issued. That is family based. But there is also a removal of condition in employment based. In employment based category that is known as EB5, that is investment. For those who are applying for green card through investment, again, everyone, 100%, everyone applying for green card through investment usually get a conditional green card. Nobody apply for green card through investment and then get a 10-year green card. No, that is not the law. Everyone applying for green card through investment, they are first given a conditional green card. The reason is this: when you want to invest, you are going to make a lot of promises. Related to terrorism is not stolen money, the money is legitimate. Those are the kind of things that you show at the time of filing. However, after they give you the conditional green card, everything that you tell them at the beginning, that okay, I'm going to build this, I'm going to employ these people here, I'm going to do this, all those things at the beginning, you are just making promises. All you show at the beginning is, okay, this is the money, this is the source of the money, and this is what I'm going to do with the money. So you are making promises. You have not actually hired anybody at that stage. You are just telling them you will hire at least 10 Americans. But by the time they give you the conditional green card, when it is time to expire, you have to apply for a removal of condition. It is at this stage that you will have the opportunity to show them that everything you promised that you are going to do, you actually did. If you promise you are going to employ at least 10 Americans, you have to show evidence now, documentary evidence of the employment. If you promise that you are going to create jobs, you have to show evidence, documentary evidence of the number of jobs created. So that is why there is removal of condition for investment through a green card through investment. So it is not only family-based petition. We have a conditional green card, removal of condition in employment-based, and we also have removal of condition in family-based petitions. The next question. Is removal okay? Next question. Can I refile a removal of 751 if I've been denied in the past? Well, it depends. If you have a justifiable reason for refiling, you may be able to refile. But most of the time, if you have been placed in removal proceedings, then you automatically have the opportunity to resubmit a removal of condition application in court for the court to re-examine it and adjudicate it. So you can do that. But you, in some limited situations, if you can justify the reason, you can also refile it with USCIS. Next question. People that get conditional residency. If you are filing, applying for green card based on marriage, if on the day the application is to be adjudicated, if your green card, if your marriage is less than 2 years on that date, then you get conditional green card. On the other hand, if your marriage has been up to 2 years, you don't get conditional green card, you get a 10-year green card. So it is not everybody. Also, in the employment based, only the investment, only for those who get their green card through investment that can get conditional green card. For every other category filing 751, no, you cannot. Because if you are given a conditional green card which expires in 2 years, if you fail to apply for a removal of condition after the 2 years, then you are out of status. So you are no longer a resident. So you cannot have a basis to apply for citizenship. You cannot have a basis. So for you to apply for citizenship, you must meet the minimum requirement. And the requirement, depending on your category, is that you must have been a permanent resident for at least 3 years. For those who are married to US citizens, you must have been a permanent resident for at least 5 years for other categories of people. So if your conditional green card expires in 2 years and you did not apply to extend it, you did not apply to remove the condition, it means that your residency is over. It means that you are no longer a permanent resident. So there cannot be a basis for you to apply for citizenship. The next question. I'm a permanent resident and my conditions were removed. My 10-year green card is about to expire. Do I have to renew it? What happens if I don't? Do I stop being a permanent resident? Well, I don't even know why you will keep your green card for 10 years without applying for citizenship. But again, if for any reason you choose to keep it, you choose not to apply for citizenship, then you have the option to continue renewing your green card. However, if you fail to renew it, it does not stop you from being a permanent resident. What it does is that it stops you from enjoying some of the benefits of permanent residency, but it does not stop you from being a permanent resident. For example, if you need to travel out of the country, you cannot travel with an expired green card. If you do, you may not be able to come in. So, a permanent resident, you may not be able to enjoy it. But does it terminate your permanent residency? No, you still remain a permanent resident. So, green card itself is what you show as evidence of your permanent residency. It is not the permanent residence, but it is just an evidence of your permanent residency. For example, if you know how to drive a car, you are a driver. If you apply for driver's license and they give you a driver's license that is valid for 5 years, at the expiration of 5 years, does it mean you no longer know how to drive? No, you still know how to drive. But what you don't have is the evidence that you are a driver. So you may stop enjoying the benefit of a driver, because if you drive without a license, the police can stop you and give you a citation. So the benefit is what you will stop. But being a driver is something that you still continue to enjoy, because you already know how to drive and you still know how to drive. The expiration of the driver license is not going to take your knowledge of driving away. So it is the same thing with green card. So you are already a permanent residency, except a court of law residency. It is only after that that you stop being a permanent resident. But even if USCI decide to revoke it, they will still place you in removal proceedings, and you have the option for the court to review the revocation. So that itself may still not take away the permanent residency from you. So being a permanent resident is different from having a document to show as evidence of permanent residence in the US in order to apply for removal of condition. Of course, there are a few examples. I say example, there are a few exceptions. There are a few exceptions to the rule. For example, if you are working for a US company, a US company removal of condition outside of the US through the US embassy. If you are working for a United States-based non-profit organization, you can apply for removal of condition outside the US through a US consulate. So those are some of, or if you are in active military, or your spouse is in active military and you are out there with your spouse, yes, you can apply for removal of condition outside of the United States. So those are the exceptions for physical presence requirement for the purpose of applying for a removal of condition. Next question. I am applying for I-751 based on marriage. Can I include my children in my petition? Yes, if all of you, if you included your children at the time you are applying for the green card in the first place, yes, you can continue to include them. But if you didn't include your children at the initial filing, you cannot suddenly include them when you are applying for removal of condition. So it is only if you included them at the initial stage. Because for anybody to apply for a removal of condition, they need to have been in possession of a conditional them. Otherwise, you cannot include them. The next question. Do I need to file for a work permit pending the adjudication of my removal of condition? No. You do not. A conditional green card is still a permanent residency. Everything that a green card holder can do with their green card is what a conditional resident can also do with their green card. A green card holder can travel out of the US. A conditional green card holder can use it to travel out of the US. A green card holder can get 6-year work authorization, employment, 6 years driver license. A conditional green card holder can also get 6 years driver license. They don't even write it on the green card that this one is a conditional green card holder. No, it is exactly the same thing that you have in a 10-year green card that you have in a conditional green card. The only difference is the expiration. Expiration is the only difference. So the date that the green card will expire, in the case of people with 10 permanent green card, it will show 10 years time. In the case of a conditional green card, it will show 2 years. It is only the date of expiration that can tell you the difference between the two. Otherwise, there is no difference between a conditional green card and a 10-year green card. So they can all do the same thing. So you can use it to work. You do not need a work authorization. And let me go back to that question. Do I need to file for a work permit pending the adjudication? No. So you use your green card. You don't need to apply for a work permit. Even while the petition is pending, you get either 18-month extension or 24-month extension. You can continue to use that to do whatever you do with your green card. In addition to that, you can also get your passport stamped after the expiration of the 18-month or 24-month. They can continue to stamp it for you for a period of 1 year to show that you are still a permanent resident. And you can use that stamp to travel out of the country, to get employment. Everything you can use your green card for, you can also use the stamp for. The next question: do I need a lawyer to represent me during the I-751 interview? That is entirely at your discretion. I mean, you can go on your own. You can also seek the advice of a lawyer. That is completely optional to you. The truth of the matter is that questions they are going to ask you there are going to be about your relationship. It's not going to be about the lawyer. It's going to be about your relationship. So if you are comfortable with your relationship and you believe that there is no question they can answer that you cannot handle, you can do it yourself, but it's optional to you. But of course, having a lawyer will have its own benefit. For example, if you are separated from your spouse, because a lawyer will be present, every question that is asked, each of you, the lawyer will have access to it. But where a lawyer is not present, if you are separated, sometimes I've seen some mischievous officers where they will trick you. They will tell you that, oh, your husband said this or your wife said this. Meanwhile, your husband or your wife didn't say those things, but they just said those things to elicit a response from you to see what your reaction will be. But with a lawyer being present, no officer can do that in the presence of a lawyer. I personally have represented a client in a family-based petition where the parties were separated. And during the course of the interview, I told the officer, we are stopping this interview. We don't want to continue. The petitioner was looking at me, but I didn't tell you to stop. But I advised her right there that we are stopping this interview at this time. So when we came out of the immigration office, the beneficiary was mad at me when the petitioner told the beneficiary that the lawyer stopped the interview. But I told them that they should come to my office, that we will continue the conversation when we get to the office. So when they came to the office, I explained to them the consequence of the direction the interview was going and the reason why I had to stop the interview. They were grateful, even though they still didn't understand the impact until years after. They continue to thank me to this day. If a lawyer was not there, they were already digging their own graves, but they didn't know. Innocently, there are some things that you say and you think that, oh, of course, the officer will be encouraging you and you will think that, oh, we are flowing. But you don't know the implication. But with a lawyer there, a lawyer can analyze the situation and then take appropriate steps if necessary. So, certain things you may be able to do yourself, certain things you may need a lawyer, but it is optional to you. Let's see. Okay, the next question. Can I-751 be denied without interview? It is unlikely. The answer is yes, but it is unlikely. It is unlikely because immigration will not take decision based on speculation. They will not take decision based on speculation. There is a reason why the criminal justice system here is different from those of other countries. Here, investigations are conducted before allegations are made. So even if there are red flags in your case, even if an officer believes that something is not right, the law mandates that that thing that is not right, the officer must either investigate it or bring it to your attention and give you an opportunity to respond to it before they can take a decision. So if there is a red flag, if they believe that this marriage is not legit, the red flag will trigger investigation. So they can investigate it. They can refer it to the fraud department. They can conduct physical site inspection. They can ask questions. They can do all of those things. It is within their authority. On the other hand, if they believe they don't want to go through that route, they already have more than enough information, then they have to issue what is called notice of intent to deny. Notice of intent to deny, because they need to bring it to your attention that, look, this is what we have found. And they have to give you 30 days to respond to those notices. Because sometimes what they think they found may be something that you can explain away. It may be something that you may have justification for. So they cannot just go ahead and deny it without giving you that opportunity. So they have to issue a notice of intent to deny and then give you an opportunity to respond to it, at least give you 30 days notice. Now, personally, I've seen an officer who adjudicated an I-130 petition and denied it without issuing a notice of intent to deny. And of course, if you have ever seen me in court, you will know that that is like giving me an instrument of battle. So I lashed out at immigration in court, because in that particular case, my client was in removal proceedings. So I lashed out to the extent that the judge turned to the lawyer representing the government that, what do you say to it? The lawyer had to distance himself from the case, that, well, this is not us. We don't know anything about it. And the judge asked me, do you have another copy of the I-130 petition, the complete set? I said I do. And the judge collected a complete copy from me and handed it over to the lawyer, to the government lawyer, and asked them to go and re-adjudicate it. That client is a U.S. citizen today. So that is a violation of the law. But if you don't have a lawyer, this is one of the benefits of having a lawyer. If you don't have a lawyer, if that happens, you don't get the benefit. You don't get that kind of service. Next question. Okay, next question. Can my U.S. citizen spouse withdraw from I-751? Yes. A petitioner can notify immigration at any time of his or her position regarding your petition. For I-751, a petitioner may not be able to withdraw it, but a petitioner may withdraw his or her consent from the petition. A petitioner can send a letter to immigration that, well, I'm no longer involved in this petition. I'm no longer married to this petitioner. I don't want to have anything to do with this petition, but he cannot withdraw it. Now, that is different in the case of I-130. In the case of I-130 petition for alien relative, it is only the petitioner who can withdraw. So the petitioner can just write a letter to immigration, I wish to withdraw my petition. That's it. That case is closed. Even a beneficiary cannot write a letter to immigration to request to withdraw an I-130 petition. USCIS will not honor such a letter because the beneficiary does not have the authority to withdraw I-130 petition. But a beneficiary can withdraw I-751. A beneficiary can withdraw I-751 because he is the applicant in that situation. Next question. I lost my conditional green card. Should I file from I-751 now? Well, you can file 751, but 751 require you to have a copy of the petition of the conditional green card. So if you did not file it before the due date, you need a copy in order to file it, because you have to show that you are a conditional resident before you can ask them to remove the condition. So if you don't have a proof that you are a conditional resident, it will be difficult for immigration to remove any condition. No, only you and your spouse need to file it, and then you need to attach evidence that you are still living together and you are commingling your asset. So you have to show all those things like bank statement, utility bill, joint tax return, birth certificate of your children, if you have children together, lease. So those are the things you need to show. You do not need affidavit of support. And of course, you need your petitioner to sign as a joint sponsor. The next question, what is the burden of proof for I-751? Well, the burden of proof is what we call preponderance of evidence, meaning that when you put a scale, when you put your evidence on a scale, okay, here is a phone that I'm holding. Let's say my two hands are the scale. So if you place this phone on one of the hands, is it going to tilt it? If it tilts it, that is what is called preponderance of the evidence. That is, in other words, 51%. That is what is called preponderance of the evidence. That is the burden of proof. You need to show by at least 51%. If it is 50-50, it means you have not met your burden. If it is less than 50, then it means that your application is not approvable. But once it is 51%, then you have met the requirement under the law. The next question. My husband is in the military, and I've heard that the process of I-751 can be expedited. Is this true? Well, not the I-751 per se. And again, not being in the military per se. What can actually expedite the entire process for you is if your husband is in active military duty. Active military duty. Let me say this. If your spouse is in active military duty, you will not even need removal of condition, because in the case of people who are in active military duty, the law requires them to be a permanent resident for 1 day. So which means you don't even need to wait for 2 years. You can get your conditional green card today, and then tomorrow your spouse who is in active military duty can apply for citizenship for you. So you skip that entire process. But active military duty. Active military duty. The next question. Is there a tip or trick to submitting a petition that is solid enough to avoid an interview? Yes, but you are asking for our work. How do I explain it? That is not a question that I can answer here. Yes, that is our work style. Yes, every lawyer has their own style. Yes, we have the way we package our petition to ensure that everything goes smoothly. That is outside of this conversation. I can only give out general information. I cannot give out work item or work secret. The last question of the day, because it's already past 1, um, I'm in removal proceedings, but my conditional card is about to expire. Can I still file Form I-751? Yes, but if you have a pending 751, if you have a valid green card, valid conditional green card, how are you in removal proceedings? So are you in removal proceedings based on criminal ground? If the answer is yes, you may be able to apply for removal of condition, but you will also need a waiver along with it if you are eligible. So it is not just for you to, this usually do not match for you to have a conditional green card and also be in removal proceedings at the same time. That is very unusual. It only happens if you have been arrested or if you have committed a criminal offense that requires your permanent residence to be taken away. So if you are still a conditional green card, yes, you may be able to file your removal of condition, but you will also need to show that you are eligible for a waiver of the criminal ground or whatever it is that took you to removal proceedings. So that is, I believe that is the last question for the day. So next week is another time. Please remember to join us next week. Join us for another session. Remember to invite your family, friends. Remember to subscribe to our channel so that whenever we go live, you will be notified. Remember to invite your co-workers. So until next week, we want to say thank you for listening to this message. Next week is another day. Remember to subscribe to our channel. Our time is 12 p.m. Central Standard Time, 1 p.m. Eastern Time, 10 a.m. Pacific Time, and currently 6 p.m. Nigerian Time. Thank you once again for listening. Have a wonderful day. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and it is like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, I have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck, because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that The entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would